Thanks for coming this morning. My name is Dana Troske. I'm a financial advisor with Mutual of Omaha. I've got an office in Lincoln, Nebraska, and one in Syracuse, Nebraska. And I'm a farm kid from northeastern South Dakota. And I've been in business about 37 years. Married a Nebraska girl. That's how I got to Lincoln in '85. So I understand how farm families work. I've got a few clients in the crowd. I deal with the same thing you guys do. I'm self-employed. I pay quarterly taxes. I got to buy my own health insurance, my own retirement plan. So I need everything that I offer to clients you guys need. And one of the biggest things I've seen over the years is people need estate planning. They should go to an expert. So about 15 years ago, I went to a seminar that Jerrod and his partner, Jim Blazek, put on. And that's when I got hooked with him. Small town attorneys are good, but they do a lot of everything. And I tell people, it's like if you got cancer or if you got a heart problem, you need a specialist. You don't go to your family practice, then he refers you to a specialist. So that's what I kind of do with Jerrod. So we work together with clients, and we sit down with clients, and we don't charge anything. We just give you an honest opinion on your current plan, or if you don't have a plan, and we don't charge you until a plan is in place. So I would just recommend, he's going to go through, this is normally an hour and a half presentation. We've got 45 minutes. So we're going to go through this, and please hold your questions till the end. Jerrod and I will be available for questions on the side afterwards for anybody that has questions. So we really appreciate you coming. There's a roster I have to pass out for attendees. We have to give my broker-dealer attendance and names, so I'll pass that out after we get started. But again, it's about 45 minutes. I appreciate you coming, and thanks for coming. I'll turn it over to Jerrod Gregg.
Thanks, Dana. Everybody hear me? Okay. Like Dana said, I'm an attorney. We just do one thing. We just do estate planning. So my goal today is kind of give everybody here sort of an overview of estate planning topics, things to be thinking about. We can't get too deep into anything in our 45 minutes, but hopefully this will kind of make you more curious about some issues, and like Dana says, we can stick around afterwards and answer questions for as long as you want, okay? So, and you have the slides I'm showing in front of you as well as a handout, okay? So the name of the law firm is Blazek and Gregg, Estate Planning Law Group of Blazek and Gregg. I'm the Gregg, Jerrod Gregg's my name. Again, all our practice does is create plans. We maintain plans over time, and we're administering estate plans when people pass, when clients pass away. And we really don't need criminal law or litigation or anything like that. We're in Nebraska, Iowa, and Colorado. We will work in other states. We've worked in Kansas a lot. We end up co-counseling with other attorneys in Kansas to help people in Kansas, Missouri, quite frankly, all over the United States. Because of the nature of estate planning, it just so happens most of our estate planning clients are farm ranch families because of the unique needs that they have. There's certain set of concerns or issues that come up for farm families that a lot of times city, clients really don't have. So, at least for my clients personally, the vast majority of them are farm families. There's 4 attorneys in the firm. Me, I'm Jerrod. Jim is the old guy in the firm, and Paul, and then Tyler's the newest one in the firm. So you just get to hear one attorney today, so that's probably good. Make this go a lot faster. I have to sort of announce this with every public group I speak to. I'm here to answer your questions, give you some ideas, give you some sort of topics to think about. By you coming to this seminar does not make you my client. I think everybody knows that, but I got to tell you that. Okay, that's the rules I have to follow. All right. So with that all out of the way, what is estate planning essentially? Estate planning is really the process to get stuff, valuables, heirlooms, land, equipment, money to your loved ones. We all face this transfer, okay? In that sense, everybody in here is the same. Everybody has stuff, everybody owns land or property or bank account, everybody passes away. And the estate planning is the process of getting that to the kids the right way, or loved ones, whoever that is. We all have that arrow we have to face, okay? Now, the next slide is probably the most important slide I would talk about today. This is a zoomed in version of that same arrow. So that arrow from you to loved ones, there's a lot of things that we list out that can get in the way of that transfer. Okay? And these are a little bit more unique for everybody. But this really encompasses my job. My job is to sit down with clients and address these potential problems, address these potential leaks to an estate, and design plans to deal with those. So at the top of the list is nursing home expenses. I put it at the top of the list now. It didn't used to be at the top of the list. I now put it there because it's probably the biggest concern most clients have. It represents the biggest potential reason why property doesn't get to kids on this list anymore. Many years ago, 10 years ago, I used to say taxes was the biggest reason, estate taxes. I don't say that anymore. Nursing home costs. Right under nursing home costs, I list procrastination. Some plans are more effective the earlier you do them. Some plans you can't do if it's too far along the line. If somebody's too old or too ill when they come in to see me for the first time, there's certain things we can't do. I would say nursing home planning for clients may be the most time-sensitive thing for anybody. So a lot of times I'll talk to clients about these issues. I always wish they would have come to talk to me 20 years earlier, because we could have done a lot more to deal with. Okay, probate expenses is the next on the list. A lot of clients ask me about probate. A lot of clients are expressing goals that they want to avoid going through probate when somebody passes away. Probate is really the court process that's required to transfer assets out of a deceased person's name. So if I own a house, I own a quarter of ground in my own name, and I die, I can have a will that says who receives my quarter of ground, but I'm not around to sign a deed to give it to them. Okay? So what has to happen is my will has to go through probate court, where the court appoints somebody else called your personal representative. And that person has the power to sign a deed to convey it to my son or whoever. Okay? That's why probate exists, to get stuff out of the deceased person's name. Okay? There's other red tape sort of things wrapped up around that, but that's the essential purpose of doing it. So if we have a plan that doesn't require the court's help to get it out of the deceased person's name, then that's going to save time, that's going to save money. Anytime we avoid court, it's going to be a more efficient process. So we set things up for farm families so we don't have to go through that probate process. Wills have to go through probate. Okay? I think I can say 100% of my farm clients don't have a will as their core estate plan. They have a trust. Okay? So a trust we can set up so that it's already preset, so we have the right trustees, the right backup trustees, so we don't need the court's help to appoint anybody, and we can make those transfers much more efficiently. Now, it's not the biggest leak on that list, but if we can save 1% or 2% of the estate by avoiding that probate court process, then it's worth doing. Estate tax, capital gains tax. In Nebraska, we have Nebraska inheritance tax. There's certain things that we can do to help with what they label death taxes at time of death. We'll get into more detail on that later. And capital gains tax and cost basis of assets are a big concern when somebody passes away. We have to have the right plan to make sure we're getting the maximum stepped up in basis on property. Okay, so that's everything above the line. Below the line are a number of items I think are often ignored. If we got husband and wife, let's say it's John and Sue, John passes away and now the assets go to Sue. That's John's number one goal, is take care of Sue. Sue's number one goal is take care of John. But if everything goes to surviving spouse, the worry could be is what would happen if surviving spouse would get remarried. And it happens. I've had clients of mine, married couples, one died and the other survivor got remarried. Might that be a reason why property goes to some other set of kids, right? So there's steps you could take in your planning to, in the event that happens, to prevent assets from leaking away to a different family. Okay, we can have those rules in place. So the whole goal of all this really is we get property with mom and dad and keep it on the right path so it sticks to to each other and the kids, so it doesn't leak away for these other things. That's the whole goal of estate planning. Plug these leaks before they happen. Creditor protections on the list. So there's a lot of things we'll do for that. Protect assets both during mom and dad's life or when the kids inherit a farm. How to protect the farm from liabilities that might arise. Even if it's co-owned by non-farming kids, we don't want a liability of a non-farming child jeopardize the farming operation. Divorce of a child. I've got 3 kids. I got a trust that's set up to provide for my kids, but it's going to them in such a way that they each get their own trust when I'm gone. And it's built so that if they get a divorce, then they're not losing that inheritance in a divorce. So if they inherit land from me, my trust already is set up so that if after I'm gone they get a divorce, we're not losing that farm ground in a divorce. Right? So that's a leak. That's a potential reason why property goes the wrong direction. We can address it. Then death of a child. I've got clients who have grandkids that are in the operation. That they want to make sure, my clients want to make sure that this grandkid is the next step. So we set up trust so that it goes to my child or children, but after they're gone, we're presetting where it would go next to which grandchild. And again, if we can see that far in the future, we have that knowledge of who's going to be taking over the farm. We can pre-plan that in these trusts. Okay? And then last on the list says special needs beneficiary. So there are steps that we can take so that when kids inherit property, if there's a bump in the road in that kid's life, if there's a medical issue, if a child would need, have a bad accident and qualify for, let's say, Medicaid, if they inherit farm ground or money or anything, like through a will outright, that would disqualify that child from that assistance, and they would have to sell everything before they could get back on it and use that money up. Whereas in a trust, set up the right way, we can pass property to kids in a special needs trust or a supplemental needs trust so that the farm wouldn't have to be sold if that kid was on Medicaid. Okay? So it's a what if, for a lot of clients. I talk to clients, they don't have any problems there. Some, we have pre-existing conditions when there's a known problem with the child, but either way we can set it up so that when kids inherit stuff, it's not going to disrupt that qualification for Medicaid or SSI and force a sale of the farm or liquidation of the asset. So in summary, this slide can encompass pretty good everything we want to know about today. I'll get into more details on each of these, but it's all these reasons why property gets away from a family. And good estate planning ought to address all of these. Okay, pre-plan for these, at least consider them, and that's really what my job is. Okay. The old style planning, like wills, don't plug any of those leaks. So a will just transfers to each other, to, husband or wife, then it transfers to the kids, have to go through probate. There is no protective element in that, okay? But we want to make that transfer happen, but also protect it when it gets there. So once it gets in the hands of my spouse or my kids, make sure that it stays on track where we want it to go. That's really what we use trust to do. So fundamentally, everybody's estate plan is built one of two ways. You got a plan based on a will, or you got a plan based on a trust. Because of the issues involved, like I said, I think 100% of my farm clients, we have a trust in place to address these issues. This slide should also be a handout that you all have, because I know you can't probably read this on the screen, but this diagram is sort of a representation of the world of estate planning. I view this as a bullseye, as a target, where you start in the middle, where it says essential planning strategies, where that's the core basic strategies that cover a lot of people. So revocable living trusts, powers of attorney, the right life insurance, nursing home insurance, those sorts of things are the first things we look at for how to protect assets. Okay? But then we can go beyond that list beyond that inner circle and get into the gold ring or the outer ring, where we look at different LLC planning, gifting planning, more advanced asset protection things. Now, not everybody does all these things, but again, these are the tools that I have when I'm sitting down with a client to pick, okay, here's what we need to use to solve this issue. Here's what we need to use to plug this leak. And we just kind of go through what applies to each client. Okay? I covered this. Any estate that has land that has farm ground in it is worth more than $500,000. Anything over $500,000, I'm typically doing trusts. Okay, I do a lot of wills too, but not for farm clients. Now, I was describing to you all that wills don't protect property. Trusts can be designed to protect things. Okay, so when somebody dies, we can design a trust so that property is distributed in such a way that's protected in that recipient's hands. Okay, so this slide sort of is an example of those different ways of doing that. So on the very left side here, it says outright distribution. That's more like a will. So you can have trusts, and I've seen trusts that say, okay, when mom and dad are gone, everything just goes outright to the kids. That's a permissible way of doing things, but there is no protective element in that. You're not doing anything to protect against a disabled child or the divorce of a child or a spouse getting remarried. None of those things are addressed with that. It's a simple version of a plan. The other type of plan you see a lot says installment. Installment means you get the inheritance in chunks. So you'll see these wills or trusts say, okay, when a child reaches age 25, he can receive 1/3 of his inheritance. Or when the child hits age 30, he gets another chunk, and at age 35, he can have it all outright. So that type of plan is there to protect property in the event a child is too young. You don't want them to have full control in their 20s, let's say. Okay? But once they're old enough, it's the same as outright. They just have it. It's just to slow a young kid down so they don't blow through it so fast. The next thing on the list says discretionary trust, and my nickname for that is lockbox trust. So I said I've got a trust for my kids. And I said each of my kids is going to receive a separate trust that they inherit from me. That's what that is. It's a discretionary lockbox trust, which says that if they're old enough, they're in charge of it. Okay? They can get at it, they're their own boss, but if the wrong thing happens in their life, if there's an accident, disability, divorce, those inherited assets are protected in that trust for that child. Okay? So it's a pretty good, cool, common way that we use to give the child a lot of flexibility, but at the same time give the child a lot of protection in case there's something going on in their life. Okay? That's kind of a diagram of it. So the idea is, I always envision this box where this stuff comes in this box, and I like the imagery of a lockbox where somebody has the key to the lockbox. Somebody's the gatekeeper of whatever's in that safe. Okay? That's the trustee. Okay? Now the trustee could be the kid. So if this, the son here is Billy, so Billy is the beneficiary of that trust. Billy can also be the gatekeeper. He can also be holding the key to get in it. But he can keep other people out. Okay? So I like that analogy. Now sometimes we'll have clients where Billy shouldn't have the key, right? So you can have a situation where Billy's the beneficiary of this trust, but somebody else is the gatekeeper, somebody else is holding the key. That's a separate trustee you can have. Okay? You can design these any number of ways. Okay? But we like having things passed down to children in trust to give them the option to protect that property if they need to. Okay, so go back one. The last thing was exempt legacy trust. So jump forward, there's the lockbox trust, and then this is that exempt legacy trust. It's very similar to what I just talked about, where we're passing property to kids that's protected, but we're taking it one step further. Is you can design trust shares for each child so that that child has life use of it, life enjoyment of it. They farm it. They get the money off the farm. They control it. but you can design the trust so that that value, that farm, is not includable in their estate when they die. So when we look at long-term estate tax planning, there's ways we can design long-term trusts that can go for generation after generation to keep that same farm ground away from estate tax generation. And that's what, you know, this exempt legacy trust is designed to do. So for larger estates, or estates that, again, clients want to keep in the family long-term, oftentimes as farm ground, we look at these exempt legacy trust designs to do that, okay? So that's just some examples of how we distribute property to kids. Again, going back 2 slides, that's that sort of continuum. We're almost always in this lockbox trust or exempt legacy trust area where we're protecting property long-term for kids, okay? Okay, what time is it? All right. I want to talk about some law changes. That this slide still says new laws, but it also says 2013, so it's not that new. It's been around for a while now. And I bring this up because a lot of times people that attend events that I'm talking at have done planning in the past, okay? And I guess my theme here should be is, if anybody has done planning, you know, 2013 or prior, there's been some major law changes that may affect how you design your plan now, okay? It may require your plan to be updated. So, what's different now compared to many years ago? There's this notion of estate exemption portability, okay? So we got to take one step back here and explain what this is dealing with. When somebody dies, there's something called estate tax, okay, federal estate tax, and that applies to everybody's estate when you die. The reality is not all estates have to pay it, okay? Every estate gets an exemption amount, okay? And if your estate value is below what the exemption amount is, then there's no tax. Okay. So right now my exemption is pretty high, but let's just use the example back when we were worried about this, where exemptions were much, much lower. So there was a time where we had, you know, $1 million exemption, or $3.5 or a $5 million exemption. So if we had a husband and wife, John and Sue, okay, let's say John has $1 million exemption and then Sue has $1 million exemption, okay? We got 2 exemptions to use. If John dies and gives it all over to Sue, that's good. We want to take care of Sue. Number 1 goal is take care of Sue. It was a bad tax move to give it over to Sue. Because when that happened, let's say I'm John, I give it over to Sue. When I do that, I give it to a wife, it's all covered by the unlimited marital deduction. So there's no tax on that. But I have this $1 million exemption that the IRS gave me. I chose not to use it. I wasted it. I gave it all to my wife. It's covered by the marital deduction, but I wasted my $1 million exemption. So going forward, Sue just has her $1 million exemption to go through, okay? So by doing that type of plan, we wasted one of the exemptions, okay? Now, a lot of the old planning was designed so that one of those exemptions weren't wasted, okay? So the idea was when somebody died, when John died, he doesn't give it all to Sue outright. It went to like a marital trust or a family trust or AB trust, some name thing, a special type of trust so we wouldn't waste John's exemption, okay? If anybody's done a plan prior to 2013, it may look something like that, okay? Okay, so with that, the background, now we have this portability thing. So portability, like it sounds, means that an unused exemption, John's unused exemption, is now portable over to Sue. So with that, if I just give it to Sue, covered by the marital deduction, my unused $1 million now is moved over to her, so now she's got her exemption and my exemption added together, okay? That's a much, much better planning result. It's a much more flexible planning strategy that we can use. Some of these older plans didn't use that because it wasn't around. So one big thing that's changed is portability. The other big change is the size of the exemption. Okay? So I was giving the example of a $1 million exemption. That's actually back in 2001 now, and it's creeped up over time. Right now, it's very high. The law on the books says it's $10 million per person. Okay? The law on the books also says it's adjusted for inflation. Okay? So with the inflation adjustment, right here today, for the next few weeks, it's just over 12 million. Starting January 1, it's almost 13 million. So we've got, let's say John and Sue, married couple, we've got pretty much $13 million of exemption per person, total of 26 million, okay? That covers a lot of people, okay? So folks that, 15 years ago, or 10 years ago, whatever, did a plan worrying about estate tax, they may not have to worry so much about estate tax as it currently sits now. The problem is, what I'm getting at is, those who have done a plan years ago designed to save on estate tax, those plans probably are making other sacrifices that you don't need to make now, okay? Let's spend a little time figuring out what that is. So, I said the old way of doing things, John dies, it doesn't go to Sue, it goes to something else for Sue. A lot of times, it was called something like a family trust, or sometimes some attorneys would call this a credit shelter trust. Some attorneys would call it a B trust, like an A-B trust. And the idea of the family trust was to use John's exemption when he died. So this is for Sue, okay? We're taking care of Sue, but we're doing it so we don't waste John's exemption. Well, one of the downsides of that, one of the side effects of that, is when this family trust is over, when Sue is gone and it goes out to the kids, when that happens, that's not part of Sue's estate for tax purposes. That's good for estate tax. That's bad for capital gains tax. The land, the assets do not get a stepped up in cost basis when Sue dies with that plan. So we did this back in, let's say 2010, we were looking to save on the big bad estate tax. That was great then, but if that's still in place now, it's probably unnecessarily giving up stepped up basis, and it's unnecessarily causing the kids capital gains tax later, okay? So there's a ton of plans that I did just like this prior to 2013. The issue, we get a hold of everybody, try to update everybody's plan, get them to come back in to do something else, and I would focus on this side now. So if I'm doing a plan from scratch for somebody, it's not going to a family trust, it's going to what I label a marital trust. That's also for Sue, but it's a marital trust because it's describing what it's doing. It's describing what exemptions it qualifies for. So it's a marital trust that qualifies for the unlimited marital deduction. So if John has, an estate of 5 million, it comes down over here into the marital trust. It's all covered by the marital deduction. He has 5 million of unused exemption. That's okay, it's not wasted. That becomes portable over to Sue, so now she has her exemption and his together, okay? So I guess I should say under today's numbers, he had a $5 million estate, it's all covered, but he's got 13 of exemption, so there's 26 total of estate tax exemption that Sue has that covers that, that covers what comes out. So that's a better plan because now we've designed it so whenever it comes out of here, if it's under 26 million, there's no tax. That's good. But we're getting a stepped up basis on everything again. That's the result that we want, okay? So that type of plan covers most people now. You may hear talk of Congress trying to maybe change what the estate tax exemption is, and we are subject to that going forward. So right now we got a $13 million exemption. Last year there was a push to change the exemption, didn't pass. On the books right now, the estate tax exemption should be about cut in half at the end of 2025. Okay, so we got to be prepared for that. But with this in place, let's say John dies this year, and he has a $12 million exemption. That $12 million is moved over to Sue, so she's locked in at John's 12 million. She's got his 12 million. She's also got a 12 million. But Congress can lower hers down, so Congress can change the law and take her exemption away from her. Some of it, let's say. Let's say it cuts in half, and then she's got a $6 million exemption. That might worry some Sue out there, but if she's also got 12 million of John's, now she's at 18, and she's still got a lot to cover the farm. So the design like this, we're looking to lock in exemptions as quickly as we can, well, as soon as somebody dies, to make sure we're covering as much of the estate with the exemptions that we have. Okay? So the lesson of this whole last 10 minutes is if anybody out here has done a plan in the past, and it has any age on it at all, you probably ought to have it relooked at, just to make sure it's up to speed and using the right exemptions. You might not be getting the stepped up basis that you should be now. Okay? All right. Most older trusts are kind of the old version. They don't save on capital gains tax. The theme, broadly speaking, from 10,000 feet above is farm families, ranch families are better off with these trusts. Okay? I could get into another 45 minutes of the more detailed reasons why, but just because of the values involved to keep the farm in the family, the tax issues involved, we're putting our clients in trust rather than in wills. Okay? So if anybody out here has done a trust years ago, have it relooked at. Quite frankly, if any of you own farm ground and have a will as your estate plan, I don't know your situation exactly, but my guess is you ought to have a trust, just because of what we can do to protect things. Okay? All right. I want to spend a little time on LLCs, and then we're doing a lot of these for clients for certain reasons. There's not a lot of slides on this. I want to just talk about it, and then I want to spend a little time on nursing home issues, nursing home planning, and things we can do. Okay. So up till now, we've talked about how do we transfer assets at time of death to loved ones. That's your will, that's your trust, okay? To go along with that, oftentimes we're forming LLCs for clients. An LLC is not an estate plan. An LLC doesn't say how things go down to my kids, okay? Like a trust does. An LLC is a business entity that we set up to own the farm ground. Stands for limited liability company. So people heard of corporations, there's LLCs, there's limited partnerships, there's all these different variables. LLCs is a good example to go through. There's a lot of reasons why we do LLCs for clients. The setup is like this. Imagine you all own farm ground. Let's create this LLC, and I just always think of it as this bubble, that we're going to put all the land inside this LLC bubble. And so we create this LLC, we name it something, XYZ LLC. Okay? We can think of another name that's better than that. Nebraska Farms LLC. That's the name of our LLC. And so we retitle all the ground into Nebraska Farms LLC. Okay? So Nebraska Farms LLC is what owns the ground. I don't own the ground anymore. Okay? My LLC owns my ground. I'm still farming the ground, so what I'm going to do is I'm going to pay rent to my LLC. Okay? I farm it, I cut corn, I pick corn, I sell it when I want to, I raise cows, that's all my business, has nothing to do with the LLC. I'm just paying a rent to my LLC. Okay? Now, the rent is the only income to that LLC. I have full control over the LLC, or me and my wife have full control over the LLC. I'm just paying this separate landowner now that I control. Okay? So when I do that, for a lot of clients, it's going to help us save on self-employment tax. So when I sell corn, I'm in that business. My CPA would say that's your active trade or business income. I've got to pay self-employment tax on my active trade or business income. When I pay rent to my LLC, I get to deduct that off of my active trade or business income, thereby lowering my self-employment tax. So I have clients that do that just for that reason. Okay. I have clients that do it to shift income. So I said, me and my wife are the only ones that are owners of this LLC. Well, what if I bring my kids as partial owners of this LLC with us? So I have some shares, my wife has some shares, and my kids have some shares. So now when that income goes into the LLC, it's not just coming back to me and my wife, it's split amongst all the members or shareholders, whatever you want to call them. So I've had clients later in life who aren't as active in the farm anymore, they're looking to get out, and they start shifting, they don't need all the income anymore, they start shifting their income to kids. Maybe kids that are in the lower tax bracket. So they shift that over by giving those shares away, and now we shove that income towards them, make them pay income tax on it, instead of mom and dad. So we'll do it for that reason. Probably the third thing on this list, and might be the biggest reason we do this, is protect the farming operation. So let's imagine we got 4 kids. We got 1 child on the farm and 3 kids who live in town that do other stuff, okay? If mom and dad die and they just pass the farm to the 4 kids, they can do whatever they want. Let's say it goes equally to the 4 kids. Now the land is owned a fourth with everybody, okay? A situation that can create, it can be problematic, it can cause some tension between farming kid and non-farming kids, okay? So, for example, we don't want a situation where the 3 non-farming kids can gang up on the farming kid and say, we need money, let's sell land, we gotta do this. We can't have a situation where somebody, gets sued for something and it infects the whole farm. We can't have a situation where somebody, had a bad day at the track and they need to go get some money fast. They want to, start a partition action against the other 3's wishes. These are all hopefully rare situations, but they're possible situations that can occur if instead we have assets in an LLC. The kids don't inherit a deed, a fourth. The land stays in the LLC. It's just now the kids are these shareholders or these members. In your operating agreement, your rule book for the LLC can eliminate these problems. Your rule book could say the 3 can't gang up on the 1 farming child. It takes 100% vote to sell land. Okay, that protects the farming child. If this non-farming kid has a bad liability, credit card problem, has a car wreck, has a bad illness, something that happens, that's an outside creditor that's not going to jeopardize the farm. They can't foreclose on the farm because this outside person has a creditor. Okay? If they just own the deed a fourth across the board, they could. The farm's fair game. So we want to protect the farming child from the unforeseen events that might pop up with these non-farming kids. Now the opposite is true too. We want to protect the non-farming kids' interests as well. Mom and dad gave it to everybody. So we want these 3 non-farming kids to benefit from this ownership in some way. So non-farming kids, they get a piece of that rent every year. Farming child has to pay fair market rent. 1/4 of it comes back to him. He's got a good deal on rent, but 3/4 of the rent comes to these other kids. So they see a benefit of owning this thing. So both groups are benefited by it. So we're trying to manage these relationships so there's not people butting heads later after mom and dad are gone that disrupt the farm. Basically with that setup, you can set it up so that as long as somebody wants to keep owning the land stays in the family. Okay? If all 4 of them decide not to own it anymore, then it can shut down and they can all get out. But that protects the legacy of the farm long term. That's probably the biggest reason why clients do an LLC, is that long-term view, keeping it in their farm. And it's all based on how you design the rule book of the LLC to make sure these rules are set right. Okay? So, an LLC is not an estate plan. My trust says how things inherit, but they don't inherit land, they inherit my LLC that I form now, with these rules attached to keep it in the family. So usually the LLC and the trust work hand in hand with a lot of my farm clients. Okay? Okay. So if you haven't considered an LLC, there's some real attributes for that, to do that. Okay. I want to spend a couple minutes here on nursing home planning because I get so many questions on this. So the 3 big topics: trust to how things are going to pass, LLC, do different things to help keep it in the family long term. Nursing home planning is not what's happening at time of death, it's what's happening during life. How do we protect the farm if I have to go in a nursing home long term? Okay? Stick with this slide. If I go in a nursing home, there's something out there called Medicaid. Medicaid is a state-run program that will help pay my way in the nursing home, but they won't pay until I've spent down my assets to a requisite level. I got to be broke enough and poor enough or sick enough to be in a nursing home to qualify for Medicaid. Okay. If I go in and I apply for Medicaid, I got to disclose everything that I own, and I'm going to be put on a spend down schedule to a certain level to get Medicaid. Okay, so if we're worried about losing assets, losing the farm in case I go in a nursing home, the first line of defense against any of that is you got to look at different pre-planning strategies, either long-term care insurance, life insurance strategies, different life insurance with different riders that have ways of you can get this benefit or pot of money to help pay for that stuff. Okay, so I got a lot of clients that I always recommend that's your first choice. I've had Dana help a lot of my clients to get those products in place. That's their nursing home plan. Okay, if that's not possible, then the answer is you could get into gifting strategies. Okay, gifting strategies basically center around rules that say if I go in a nursing home, if I don't own it, then I don't have to disclose it on that list, right? And I don't have to spend it down. Well, you just can't unload everything the day before you go in the nursing home. So there's look back periods. They say you got to make a gift 5 years before you apply for Medicaid. Okay. So there's gifting rules that apply for the IRS. Basically, the gist of this slide is if we're gifting for nursing home purposes, don't worry about gift tax rules. I can explain it to you in 10 minutes after the event is over, but you can give whatever you want away. If you want to give a $10 million farm away all in one swoop, you can, okay? Despite what you've heard about gift tax, you can do that. What we typically do is don't give to a child. So if I have a farm and I want to preserve it in case I go in a nursing home, I could just deed it all over to my son. No offense against my son, but if I did that, now if he has an accident, liability, divorce, any of those things, that could affect the farm negatively, right? So we're moving big assets around. We don't give it to kids, okay? You want to give it to a specialized design trust for this purpose. We would give it to what we term a Medicaid Asset Protection Trust. We abbreviate it MAPT, okay? So it's a trust that we can put assets into that'll, after 5 years, protect those assets from the nursing home, but it's not in the kid's own name, okay? Again, it will protect it in case that child dies. We don't want it to go the wrong direction. It's not in the child's name, it's in the trust. It would protect it if that child had to go to a nursing home someday, or children. And a biggie is we help preserve cost basis step up. If I give it all to my kid and I don't own it at my death, there's no stepped up basis, which is bad. So when we give it to the right type of trust, it will still be stepped up at my death. So again, in a nutshell, we create this irrevocable gifting trust. That's this map we're moving stuff into. We can be proactive and make smart gifts to protect those assets, okay? These strategies are not the first choice. The first choice is have the right insurance in place, okay? But this is here to help clients who, because of age or illness, can't qualify for long-term care insurance or the right life insurance to take care of this stuff, okay? Again, these issues here, much more clients have to deal with this nursing home planning than they do estate tax. Everybody talks about estate tax, but again, that only bothers people now if they've got 26 million from married couple. This is the bigger issue. So if you haven't addressed the issue of nursing home planning, it's time sensitive. The earlier you do it, the better. And I encourage all of you to look at those types. And there's a lot of variation in here that we can talk in more detail after the event's over if anybody has any questions. But I think we're about out of time. You can put life insurance in these gifting trusts. So I spoke about that. So if you get life insurance, you can transfer that to the kids in case the nursing home takes other stuff. We can give more detail on that too. We probably hit on 4 or 5 of these items on this circle, okay? But that just kind of gives you an idea of the scope of what's available, and it's different for every client, okay? So hopefully today gave you a little bit of an overview of kind of what's out there, what issues. I encourage all of you to talk to an expert in this field to make sure that you know what your options are. Too many I've talked to clients where they just didn't know that they could do things to protect assets from a nursing home. They just thought if they went to a nursing home, they lost everything. There are strategies that you can use if you're proactive, okay? Okay. That's all the time I have. I think we're at 45 minutes. Thanks for your attention. Thanks for, if you have questions, you held off, thank you. We're gonna step aside and meet somewhere out here. If anybody have any questions, I'll stay as long as we need to answer questions, okay? Thank you, everybody.